Good morning, everyone. My name is Jin Kang. I'm the Global Head of Legal at Hashed. And today, I'm incredibly honored and privileged to introduce you to SEC Commissioner Mark Uyeda. Commissioner Uyeda, first of all, welcome to Korea. I know that your reputation precedes you, but could you be kind enough to introduce yourself to the public and perhaps your first impression while in South Korea?
Great. Well, thank you, Jen. It's a pleasure to be back here in Korea. This is actually my fourth time here in my life, and it is just, I think, a very terrific place to come visit. I'm very excited to be here at Korea Blockchain Week to see and hear from a lot of the participants in this evolving and innovative area. So just a little bit about me. I am one of 5 commissioners who comprise the U.S. Securities and Exchange Commission. We are led by a chairman, Gary Gensler, who sets our regulatory agenda. I have a fixed term, which goes through June of 2028. So because there are 5 of us, the views I express today represent my own views as an individual commissioner and not necessarily the views of the full commission or any of the other commissioners.
Great. So let's start with the basics. How does the SEC have mandate over digital assets, and what are some of the regulatory approach in digital assets in general, please?
So let's be clear. What we have at the SEC is jurisdiction over securities, and digital assets may or may not be a security, and it depends on whether it falls within the statutory definition. Now, for those who have been at all involved in thinking about whether or not you want to be involved in digital assets in the United States, you probably hear something called Howey. Howey is thrown out a lot, and Howey is a reference to a case from many decades ago called SEC versus W.J. Howey and Company. And within our jurisdiction, we have fairly common traditional devices like securities or like common stock, bonds, but we also have something called the investment contract. And the Supreme Court in this decision, the U.S. Supreme Court said, you are a security as an investment contract if it involves an investment of money in a common enterprise with the expectation of profits from the efforts of others. Now, what this means is if you satisfy that definition, then you're going to fall within our jurisdiction. And if you don't, then you might fall under the regulatory ambit of some other regulator, but not the SEC.
Great. In the beginning, you mentioned that there are 5 commissioners. So could you elaborate on some of the internal dynamics between the commissioners, and how does the decision-making process happen in general within the SEC?
I should also point out that we have a staff of over 4,900 employees at 11 regional offices throughout the United States. So what that means is a significant amount of what we do is carried out through our staff, and then ultimately they come up to the 5-member commission for approval. Now, what's important to note is that except for the very small number of individuals who report directly to me on my personal staff or to one of the other commissioners on their personal staffs, everyone else of those 4,900 report to our chairman, Gary Gensler. And that's something that by law he is in effect, the president and CEO of the SEC, which means he decides what the commission as a 5-member body votes upon. He decides and has oversight over our enforcement division, so what cases they bring, which ultimately come up to the commission at the very end of the process to approve. But all of that falls strictly within the responsibilities of the SEC chairman. So he or she, as the case may be, who sits as the chairman has an extremely enormous amount of regulatory power by acting through the staff for actions that don't require the full 5-member commission approval.
Great. So I would like to go over some of the public statements that you have made, especially this year. So I would like to go back to January when Bitcoin ETF was approved, and it was a historic moment for the industry. However, there were some suggestions that you did not 100% agree with the rationale for approving it. Could you elaborate on your logic and tell us a little bit more about it?
Yeah, so prior to this year, we had already approved Bitcoin futures exchange-traded products. And now we had, that followed those approvals, spot Bitcoin exchange-traded products that were coming up. And the SEC had previously said, no, we are not going to approve those for listing. And there was one particular party that was subject to denial. They said they exercise their legal rights that when we at the SEC make a decision, they can have that reviewed by our judicial system, our courts. And so they appealed to the U.S. Court of Appeals for the District of Columbia Circuit. The Court of Appeals said, we disagree with the SEC's reasoning for the denial, and they sent it back to the SEC. And so that's when it came back up before us, sitting as the 5 members, to decide, well, what were we going to do now that we had this decision from the D.C. Circuit. Ultimately, I agreed with the outcome that the spot Bitcoin ETPs should be treated no differently than the Bitcoin futures ETPs, especially when one of the concerns that we always have is whether or not there can be manipulation of the underlying prices. And when one looks not only in the Bitcoin world, but whether it's treasuries, whether it is commodities, there is a strong, very high correlation between price movements in the futures area versus the spot area. Now, why is this important is, well, we have another fellow regulator called the Commodities Futures Trading Commission, and they have regulatory oversight over the futures world. And so that is one of the factors that we think about is there market surveillance? I think in this case it's the CME that was doing it, and they're going to be subject to CFTC oversight. So we had a reasoning which, for the sake of time, I'll say I found it a bit convoluted. There's a lot of detail in there, but ultimately I agreed with the outcome. One of the things, though, that did trouble me, there was the lack of the ability to do an in-kind redemption and purchase mechanism, which is what we have for all of the other commodity ETPs out there. And so, the good news is we continue to evolve as an organization with our rules and our policy making, and so I hope at some point in the future we go back and revisit that aspect and rethink whether or not we can allow for that in-kind purchase and redemption feature for these types of ETPs.
And from the industry perspective, I think that kind of consistent, principled approach is very much appreciated as we seek further clarity within the industry going forward. Okay, so now moving slightly forward into your statement in July. It was a very unrelated statement, but there was a tiny little footnote in which you argued that the current S1 disclosure regime may need to be customized for digital assets. So this is a little bit of a loaded question, so feel free to take as much time as you need to answer it and maybe give a little bit more background for the audience. Could you elaborate what you mean by customizing that for digital assets?
So it goes back to first principles about why we even have a securities law. One of the reasons is to provide the necessary information, important information, that whoever buys a security, and let me be clear, this is once you're in that bucket that you are a security, and that comes after you've done your Howey analysis and maybe you have concluded that this ought to be treated as a security within the federal securities laws. So the law says you need to come in and either file a registration statement to register the offer or sale of that security, or find an exemption. Now, one of the important things in our laws is if you offer this generally to the public using what we call general solicitation, you need to have it registered with the SEC as a general rule, assuming that they're not accredited investors. So, throughout the course of how the SEC has historically operated, we want to make sure that what you put in that registration is relevant, but nonetheless, we have specific requirements in there. For other products, and my statement came in the context of something called registered index-linked annuities, which I will assume that none of you are that familiar with because this doesn't quite look like the annuity purchasing crowd out there. This is an insurance product, and it might appeal to certain types of purchasers. But when we have our general registration statement, because we don't have a specialized registration statement available for it, we have this general set of requirements. Tell us about the company. Tell us about its financial statements. Tell us about risks of the company and management's discussion analysis. Now, a lot of that is not particularly relevant to a purchaser of an annuity. What they want to know is, what does this annuity do? What are its features? What are its costs? Those are all things that are not part of our general registration form. So what do we acting through our staff do is we have discussions with the sponsor of that annuity product, and they make a customized set of disclosures that are relevant and important to a purchaser of that product. Well, why shouldn't we be doing the same thing with crypto digital assets that are securities? We have the flexibility to do that, and that was in part expressing my frustration that we've not done more of that to accommodate sponsors of these types of digital assets that they have concluded are securities. What we cannot do is create a catch-22 situation, such as to say, well, thank you for concluding it's a security, you need to register with us, but you now have to register and provide disclosures that are not relevant, and in some cases, you may not even be able to effectively provide like GAAP financial statements.
Thank you for that note. When I think about new emerging technology, I think of three phases in terms of legal strategies in dealing with technological adoption. First is avoidance strategy, and that was probably best exemplified by Slockit. And there is the compliance strategy, in which you try to comply to the best of your abilities. And third, you have transformative strategy. And perhaps this is best exemplified by EU's MiCA. And given that we've been discussing some of the disclosure principles also enshrined in S1, have you had a chance to consider some of the white paper disclosures requirements in EU, and how would you evaluate and assess its framework?
Well, not only the EU, but certainly from my perspective, we should be looking at a lot of jurisdictions around the world as they think about, well, how should we be handling digital assets? In some ways, the US, I think we've had a more challenging time to establish a regulatory policy. In part, we've got multiple regulators who are responsible. It's not just us and the CFTC. We also have certain aspects might be overseen by banking regulators, including the state banking regulators. So as we try to navigate what we should be doing on a policy perspective, one important activity that we should be doing is, well, looking what has been going on with the rest of the world, including in the EU with respect to MiCA, but also what's going on here in Korea, what's going on in Japan, what is Singapore doing on this. To a certain extent, they're almost natural experiments, so to speak, but one of the important things is to try to determine whether or not they are similar or different to what goes on in the United States. And this is something that I think not only we're looking at, but there are members of Congress who are very interested in this issue. We at the SEC, we are limited to implementing what the laws Congress passes. And so certainly, I know members of Congress are looking also abroad for ideas and thinking about possible legislation. And to the extent that were to occur, that's something that we would have to follow through and implement.
Essentially, what you're articulating is that as an enforcement agency, there needs to be legislative clarity first. And so in that way, I think a lot of the industry has to do a better job of communicating and collaborating with the enforcement agencies and government agencies. So to this end, you've also recently dissented against the Coinbase's petition for rulemaking process. Could you elaborate a little bit more about the rulemaking process that you have with the SEC and how you also interact with the industry at large?
So the way that regulatory, or at least the regulatory agenda is set, we publish that twice a year in something called the Federal Register, and lists every project that we have ongoing. Now, we also have something else, which is what every other administrative agency in the United States, I believe, has, which is the ability to petition the government and put forth ideas. One of the things one way to look at that is it's almost an official suggestion box from the public. That agencies generally, we can take that in and we can think about whether or not we want to act on that specific agenda item or not. I think one of the big advantages when someone files that to us is it's made public. I know there are other ways, especially in the current era where people can put together ideas and get input from others in the public. When we get that, it's really up to the chairman as to whether or not he or she wants to decide to put that on our regulatory agenda. Under the current our chairman Gensler, I know he had about 50 plus, I think, items that he added to the regulatory agenda at the start of his term, everything relating from settlement of equity securities to how we treat private funds to climate change, share repurchases. But we didn't include anything on digital assets. And again, that is the discretion of the chair. That is the chair's agenda to put forth. Personally, I hope at some point, whoever sits in, whether it's Chair Gensler or any of his successors, will think about, we've now had a fair amount of time existing with regulatory uncertainty on digital assets. Maybe we ought to move forward with some policy making or some rule making to try and clarify the boundaries of what is and isn't a security, and if it is, well, what does that mean? What does it mean if you are a broker-dealer and your responsibilities? What does it mean if you want to be an exchange or similar platform that has to deal with this? What does it mean for if you have to custody it and safeguard those? So there are all those other issues, and at some point it would be good to get some rules out there as opposed to trying to infer what the thinking is of the SEC through enforcement actions, which tend to be very retroactive in nature and not prospective.
And I can't believe we're running out of time already, but I think looking forward, I think what can you envision and perhaps what can we anticipate as an industry at large in terms of what the future role of SEC may be over the entire digital assets economy?
Well, there are a number of different, I think, factors. One of the most important ones is, I know there are numerous pieces of legislation that are being circulated in Congress. So if Congress acts, that would definitely affect what we do. With respect to our own regulatory agenda, I certainly have been vocal, as has one of my colleagues, Commissioner Hester Peirce, about the need to spell out some guidance or potentially rules about this. What I've said before is there's no reason why we can't do, for instance, an interpretive release as to how we apply the Howey test. All right, no pun intended there. But this is something that we've had to do in the past. I'll give you an example. Just 5 years ago, we did an interpretive release of what it meant to be a fiduciary if you're an investment advisor, because that was something that the Supreme Court had said. Investment advisors have a fiduciary duty, but it wasn't clear what the contours of that duty meant. So we engaged in a process where we put out, here's how we view that applying, and we then subjected it to public notice and comment on that and came out with a final interpretation. I said that the Supreme Court's ruled in this Howey opinion, but then the Howey opinion has to get interpreted by all of the different courts within the United States. And as a result, different facts and different circumstances can have differing results in particular courts. And so that's one of the things that we can do at the SEC is say, all right, now that we have this incredible body of law out there, we can go out, propose some interpretive guidance of what it means to be a security as an investment contract and what is not. We can solicit public comment on that, and come out with a rule that would be helpful not only for market participants, but also helpful for others who are trying to interpret this law, whether they're courts or other regulators, and provide that guidance. So again, everybody here will know where exactly that line is.
Thank you. I think what we need to do better as the industry is also kind of giving you more data and feedback. So thank you for your contribution so far, and we look forward to many more achievements coming your way. So thank you very much for today.